Thanks everyone for coming back on time. We appreciate that, and especially appreciate those of you who moved to the front because we've got another excellent panel. But before that, we'd like to welcome back to our stage here another one of our amazing sponsors, Intoxilac. And we'd like to ask Erica Eckley to come up and have a few words.
Good morning. I'm Erica Eckley. I'm the Vice President of Legislative Affairs for Intoxilac, and we are beyond excited to sponsor this inaugural conference and to be a part of NACID. We really appreciate all of the partnership that responsibility.org and pretty much everyone in this room has with us to help us meet our goal to just eliminate impaired driving fatalities. The work that we do is so important, and I really appreciate all the people that I've met. This is my first conference in this role, and you guys are just beyond amazing. And so I'm just really proud to be here. And I know that there's a lot of work that's been done, and I know that we're talking about new technologies and things, but it's important to remember that there's still a lot of work that needs to be done in the alcohol realm. In 2019, there were just a little over 1 million arrests for impaired driving. Of those, only about 3 in 10 of those individuals used an ignition interlock after that arrest. We need to do more to ensure that those individuals have access to a tool that does help prevent recidivism. Intoxilac, since January of this year, we have tracked over 105,000 attempts by individuals using interlocks to try to drive after having a BAC of over 0.08. This shows the need to continue to work with states to pass laws to make sure that all offenders have access to the ignition interlock and to ensure that those offenders have what we call compliance-based removal, a period of time in which they show through the logs of that interlock that they have learned that they cannot drink alcohol and then drive and make our roads unsafe. We look forward to participating in this coalition to end this impaired driving and are proud to be a member. We're also a member of the Coalition of Ignition Interlock Manufacturers. And I really adore the people that I get to work with that. Deborah Coffey, our talented new executive director, Stephanie Zugswart, sorry, Stephanie, I'll get it right one of these days. And I look forward to you guys working with us on that. The work doesn't end at the end of this conference. And I want to extend the invitation to reach out to us to partner with us in any way that you can, so that we can all work together and end impaired driving. And I really appreciate the opportunity to be here, and I appreciate all the work that you do. Thank you very much.
Thank you, Erica. This wouldn't have happened without support from Intoxilac and our other wonderful sponsors. Next, we're going to look at countermeasures. And that panel, all of our esteemed folks up here, will be led by moderator Mike Hansen from the Minnesota Office of Traffic Safety, and joined by panelist Bill Lindsey from the Alabama District Attorney's Office, Terrence Walton from the National Association of Drug Court Professionals, Judge Richard Vlavianos from San Joaquin County Superior Court, and Joanne Thomka from the National District Attorneys Association. Please join me in welcoming these panelists.
Thank you, Karen, and good morning, everybody who is both in person, and good morning to our virtual attendees as well. As Karen said, my name is Mike Hansen. I currently have the privilege of serving as the director for the Minnesota Department of Public Safety's Office of Traffic Safety. Prior to my appointment as the director in 2017, I worked in law enforcement for just shy of 35 years. So I have a well-founded appreciation for all of the professionals that I work with, both in my previous career and also in my second career, as my wife calls it. You know, there's an old saying that, you know, if you think you're the smartest person in the room, you're in the wrong room. Well, boy, am I in the right room today with the panel that we have assembled up here. This is going to be a really good discussion. While our goal is to always prevent these impaired driving offenses from occurring before they occur, We all know that human beings are fallible and they make mistakes and they are going to be arrested and they are going to find themselves in a system that is going to try and help them change their behavior. As my dad said many, many times to me as I was growing up, when I would make a mistake, well, did you learn anything? And part two of that is, don't do that again. And so that's really kind of at the heart of what we're going to discuss today. Now, I'd like to start out and just set the tone just a little bit, and I'm going to read an actual criminal complaint that one of my colleagues sent to me. That it was an event that took place in Minnesota within the last week or so. And so it starts out on April 27th, 2020, so last year. The subject, initials GP, made an initial appearance before the judge in district court on a criminal complaint charging him with 2 counts of third-degree driving while impaired, as well as other charges. The judge heard the appearance and then set conditions of release, which included a cash bond, and then subject to a number of conditions of release that included to be of good behavior, be law-abiding, that he not purchase, possess, or consume alcohol or other non-prescribed controlled substances, and that he not drive any type of motorized vehicle without a valid license, registration, and insurance, and then finally that he submits to random testing and searches requested by law enforcement upon reasonable suspicion. On or about July 1st, 2020, subject initials GP failed to appear for a pretrial hearing before His Honor in the court, and a warrant was issued for his arrest. On July 26th, 2021, at approximately 8:46 p.m., Minnesota State Patrol Trooper Aaron Boomersbach was on routine patrol on Minnesota Highway 102 in Polk County, Minnesota, when he observed a black passenger car near the intersection of 160th Avenue Southwest. Trooper Boomersbach observed that the black passenger car was stopped on the right shoulder, that it had its engine running, and that the passenger door was wide open. Trooper Boomersbach stopped his patrol vehicle behind the black passenger car to check on the occupants. Upon exiting his squad, Trooper Boomersbach approached the black passenger car and could immediately hear small children crying from inside the vehicle. Trooper Boomersbach observed that there was a female who was clearly deceased on the ground on the passenger side of the vehicle. Trooper Boomersbach further observed that there were 2 small children in the back seat of the passenger car and that there was a male individual sitting in the driver's seat of the passenger vehicle. Trooper Boomersbach noted that the male was slumped over, had a blue-gray appearance, and was not moving. Trooper Boomersbach immediately called for assistance and EMS. Polk County deputies arrived to assist, as well as the local EMS providers. Trooper Boomersbach and Deputy Olson approached the passenger car again, opened the driver's door, and upon doing so, observed a pack of beer at the feet of the male driver, as well as an open container in the center console. Trooper Boomersbach noted that the male driver had shallow breaths, had very blue-gray tone to his skin. The EMS providers arrived and immediately administered a Narcan dose to the driver. Upon the administration of the Narcan, the subject, in this case, initials GP, became responsive and eventually was able to sit up and then stand on his own. Making further inquiry, Trooper Boomersbach determined that the subject, in this case, initials GP, had overdosed on opioids of some sort. And this was later confirmed in an interview with the subject, who admitted to abusing Percocet and stated that his now deceased girlfriend, the passenger, had also consumed the same Percocet, which was later found to have been laced with fentanyl. So as we can see, the prevalence of polydrug use out there, and as Amy pointed out this morning, is vastly underreported. And it is something that we all need to be conscious of. And our panel today is going to discuss the strategies and the best practices and how we can move forward. I think, as Chris put it very well yesterday, this is going to take a 360 holistic teamwork approach to solve. And this is not going to be something that's going to be easy, and it's not going to be something that one discipline involved in this project is going to be able to do on its own. It's going to take all of us moving together. And so with that, I am going to turn the rest of the presentation over to the true experts in this field. So panel, I'm going to let you take it away.
So we started out this morning and we were talking, oh, we're going to sit there. And I'm like, I was a line prosecutor for 10 years. And every judge is in the back of my head immediately going, what are you doing? What are you doing? Stand up, right? And so I can't sit. I'm sorry. Please forgive me, Joanne, but I got to stand up when I present to anything because I'm used to presenting to a court. And I want to start out this morning by asking you, do you know what the Tsrp program is? Okay. And do you know the Tsrp or multiple TSRPs in your state? And do you frequently have conversations with them? This is I heard a few no's, but this is the first room where I got more yeses than I got no's. I've sat in a number of meetings where they didn't have a clue what I did, right? And a lot of that is on me as the TSRP. But you need to know that the Tsrp program is out there. I think Joanne's going to talk a little bit more about that. But we try to be the resource that everyone in the state needs when it comes to impaired driving. And in my role, I've tried to bring in as many stakeholders in my state to get involved in the problem of multi-drug DUIs. Because when I took over this position in 2015, I immediately got introduced to the DRE program. We did not have any DREs in the jurisdiction that I prosecuted in for a decade. So when I was prosecuting drug DUIs, I was strictly going by what the officer said and what the toxicologist would hopefully come in and say. So in talking with the DRE program and looking at the stats that Dr. Harper was collecting through ADFS, we've got a real problem. In 2015, alcohol was still the #1 drugs on our roadway, but alprazolam and THC were really catching up. And he goes, I've got this idea I've been working on. I've been working on it for a while, but I need some help promoting it. And he's like, it's oral fluid. And here's what it can do. And he's really excited about some of the field instruments that he had with him, the devices, and he was showing them to the DREs, and it got me fired up. And I said, well, here's what we got to do. We got to get everybody on board before we go forward with this. So we got all the stakeholders in the room. We got legislators, we got judges, we got probation and paroles, we got public health, we got MAD, we got all the individuals that had a vested interest and a knowing vested interest in DUI to go forward. All right? That's the 30,000 view look. You got a on the field view, or she scratched the surface yesterday with Jennifer Knudsen, right? And all the things the prosecutor has when we talk about adjudicating DUI cases, multi-drug DUI cases, or single drug DUI cases. And when I came into this position, I thought, I've got to have goals, and I've got to have short-term goals, and I've got to have long-term goals. And what were the frustrations that I had as a line prosecutor? Those should be my short-term and long-term goals, depending on how long it's going to take me to address those issues. All right? And the first thing is training. There was a lack of training when I took this position. And I know Joanne's going to speak a lot about that. But I immediately said, we've got to get training for our prosecutors and for our law enforcement. Because the individuals handling these cases, right? The prosecutors handling these cases in my state, less than 5 years experience right out of law school. Those are my prosecutors. And within 2 years, they're handling felony cases and they're not touching DUIs anymore. And then I've got a brand new group that needs to be trained. And my law enforcement, maybe they're handling it for 3 years and then they go to some other assignment. They may come back to patrol eventually, they may come back to traffic, but I've got 3 years to impress upon them what they need to know about DUI and prosecuting those cases and what were their frustrations. So I sat down with law enforcement agencies. What are some of the things that we need to address? And I'm happy today, and I'm excited today to tell you that when I go back home tomorrow, I expect to not sleep for the next week because I started working on those goals that I wrote down. And the first one was to get oral fluid involved in our implied consent program. We've been using it as consent in the state of Alabama, both the roadside test and the confirmation. But as of August 1st, it will be part of our implied consent. Now, how many of you in this room have been working in the criminal justice system since 1983? A few, right? A few. Well, 1983 was the last time anybody in the state of Alabama did anything to change implied consent. Exactly. That's my reaction too. Oh my gosh, this explains so much. We were only looking for alcohol and implied consent in Alabama, and we still are until August 1st. All right? We're only looking for alcohol. THC, cannabis, overtook alcohol 2 years ago in the state of Alabama. THC is the most common drug on our roadways in Alabama. Alcohol is second, but meth is a fast closing third. And of course, we still have alprazolam and cocaine closing in the top 5. And those are going to greatly impact all of our cases and all of our lives because we kill about 1,000 people on the roadways in Alabama every year. 30% of those are alcohol impaired drivers. I lowball the next number I'm about to give you, and I say at least another 30% are drug-based impairment fatalities, other drugs, right? My DREs would like to say, you lowball it so bad, it's closer to 60%. Because what we see is we see these multi-drug, these multi-category DUIs. We are not seeing these single category DUIs anymore. It's just not happening. So how do we help our prosecutors when we get in the courtroom? And to me, the first step was addressing the issue with implied consent so we can have things to hold over the defendant if they don't comply with what our law enforcement want them to give and want them to take, right? So we included oral fluid, and now we're looking for any impairing substance starting August 1st. Whether it's a traffic crash or whether it's a roadside stop, we're looking for any impairing substance, right? That's the first step. That was a big goal. That was almost a short-term goal for me because one of the things we did in that bill also is we included the ability for paramedics on crash scenes to take blood for criminal justice purposes. Because under Alabama law, until this bill goes into effect, the only people that could draw blood in Alabama for criminal justice purposes is a doctor or an RN. That's a real big issue for law enforcement because it takes us 2 hours to get a search warrant. I'm probably going to talk to Darren after this conference is over because I have another long-range goal that has been there that I would like to check off. I've checked off 2 of them. My third on my list is the electronic search warrants. My state has pushed back on that, but that's going to help my law enforcement and my prosecutors in the adjudication in the long run. But that's more focused on law enforcement and what they're doing out in the field, but it helps my prosecutors when we get into the courtroom. The other goal that I had that I was told this, all right, by prosecutors, by defense attorneys, by judges, it will never happen. But HGN, the most accurate field test that we have on the roadways for law enforcement to detect an impaired driver. Judges were not letting in our state. There were a few cases back in the 80s where the proper predicate wasn't laid for the admission of HGN, and so it was excluded from some DUI cases. And those cases had been used and misrepresented and said, see, the courts say it's not admissible. That's not what the opinion said at all, right? But as part of implied consent, we included in the bill some language that statutorily recognizes HGN and its admissibility in DUI cases. So I'm excited that August 1st, HGN will be admissible by statute in the state of Alabama, in all 67 counties. To me, that is a huge goal, and that was a huge check off my list. And I have been doing training since July, really since the end of June. In July, I've been to the office twice. Otherwise, I have driven literally north to south in our state and east to west. Because we want to make sure that law enforcement is trained up on the collection of oral fluid, on the implementation of implied consents, and the collection and the use of HGN in the courtroom. So we've been training that in different types of training all throughout the state. And that's what your TSRPs can do. That's just a small sample. I'm just one TSRP. I don't claim to have the greatest ideas. You've got some phenomenal all-star TSRPs out there. You've seen one yesterday in Jen. She's the rock star. You've heard from Kurt yesterday, who I say is the rock star of Alabama, and I'm just riding his coattails, right? He's led me on some great adventures, especially with this oral fluid and different things that we've been able to produce and do in the state of Alabama. And I hope you have some questions, but if not, maybe that's good too, right? But I'm going to turn it over in the rest of my time because I don't want to be accused of taking anybody else's time.
Thank you very much, Bill. Appreciate that perspective and what you bring to the panel. And I don't think you give yourself enough credit. Some of that stuff does not happen without somebody not only pushing and pulling and scratching and clawing to get it across the finish line. So thank you for that. Who's up next?
I think I'm next.
All right. Terrence, here you go.
Well, good morning, everyone.
Right.
Thank you, first of all, Mike and Bill especially, for that. To me, it was an inspiring presentation. DWI courts don't work unless all pieces are in place, and so we appreciate the role of every part of the system that helps us move forward. I'm so happy to be here on behalf of the National Association of Drug Court Professionals, and that of course includes the National Center for DUI courts for driving, DWI courts, driving while impaired courts. Our director of NCDC, Jim Aberspacher, is here as well. This is a pleasure to be here. So this is the first time I've spoken in a room in public since March. I've forgotten how to speak standing up. So I'm gonna do the best I can. It's just like, well, it's good to be back. Oh my goodness. Let's hope we can stay back, right? Yep. I don't know. So I'm not gonna talk long today at all. I want us to hear from others and us to get to some discussions together as a group. But I want to begin by sort of addressing one, I think, critical question. And that is, how does a back-end solution like DWI courts help prevent multi-substance impaired driving? How does that happen? And I'll begin by answering that in this way. One thing that we absolutely know, and that is, or I want you to know in case you don't, that DWI courts and all treatment courts are actually about preventing future recidivism. It's always about future criminal conduct. DWI courts are not about retribution. There is a place for retribution in the justice system. We need that too. That's not what DWI courts for. They're designed for individuals who we believe that based on what's driving their behavior, driving their repeat impaired driving, is a couple of things, and one big part of that is addiction. I'll talk a little bit more about that. It's super important. DWI courts help in two ways. They help sort of immediately, as soon as a person is placed in a DWI court, they help to immediately reduce the risk of impaired driving by reducing the risk that the person will drive while impaired. And that comes from supervision. That comes from ignition interlock. In fact, there's a Michigan study that indicates that when we compared DWI courts that use ignition interlock with those who do not, that those who use it have actually higher graduation rates, not lower, and lower recidivism. That extra accountability is helpful for men and women to be able to avoid driving impaired, focus on treatment until they can get control of their behavior. So through technology like that, supervision, regular, frequent contact with the judge, hoping to say, great job going to treatment, great job, senior psychologist, keep up the good work, and if not, being prepared to help the participant understand that the court expects them to abide by the treatment plan they agreed to. So that's right away. Because I am happy, and the judge will vouch for this, that we know that DWI court works. We know that treatment works. And we know that DWI court treatment works especially. But not always right away, right? It takes time for people to develop the knowledge, the skills, the ability, the motivation, and the insight it takes to move from active addiction to lasting recovery. You know, my job right now is to know all things drug court. As the chief operating officer and chief of standards, I gotta know how drug courts work in all areas. But by profession, by calling, I should say, my life has been dedicated for 3 decades to helping folks who are battling addiction. And for the bulk of that time, that has been helping people who are helping people. Because that's sort of the other side of this, that DWI courts are not just for people who drive impaired repeatedly, and that is who they're for. For many of us, and maybe some people in this room, I don't know, but for many of us, many people, you know, the first DUI was an eye-opener, and you never had to worry about that again. They were able to make whatever changes they needed to make in their life, in their practice, whatever they needed to do to be sure that never happened again. That's not who DUI courts are for. I'm glad there are options for those folks in many communities. DWI courts are for individuals where it wasn't the eye-opener because it probably couldn't be, based on underlying issues, addiction, as well as other personality traits or ways of thinking that are almost always a part of a person who is repeatedly making a decision to get behind the wheel of a vehicle when they might be impaired. That's about addiction and more, and DWI courts address all of that. That's how we help in the long run. In the short run, we help by reducing the risk that a person will drive while impaired, in the short run. In the long run, we help by reducing the risk that an addicted person will be impaired at all, because they'll receive effective treatment and recovery management, overseen by judges and others to help them maintain the motivation to keep going to treatment long enough for treatment to work. I've been on both sides. I began my career in treating addiction directly, in direct services outside of the justice system. We had some good success there. But the biggest problem wasn't that we didn't have the right tools and resources to help people get better. The biggest problem was that we couldn't keep them coming long enough for the magic to happen. DWI courts and other treatment courts help make that happen. They help people keep going, get up and go to treatment when they don't want to, help them make the right decisions when they really feel like drinking or using a substance. They'll pick up a phone instead of picking up a bottle or whatever. That's what works. And so in the long run, effectively treating addiction, as well as the kind of thinking that goes into any person, addiction or not, who makes decisions to repeatedly put themselves and others at risk by driving impaired. I want everyone to know 2 important things, and I don't assume you don't know it, but you might not. That because I have dedicated my life, aside from being sure my wife and children are well taken care of, my life is very much about helping people break free. I understand addiction for what it is. This is not I'm drinking or using because I like it and because I like to party and hey, life is, let's just live wild and free. It's not just for these people. This is I drink or use other substances even when I really don't want to. Even when I promised myself, my loved one, the judge, my PO, this is it. It's a brain, for people for whom it is addiction, it's a brain-based, neurologically based compulsion to drink or drug even when they desperately don't want to. That requires effective treatment. And so if we're working, I don't know if this is true, but I've always said to folks and believe that if you have a person who is in active addiction, actively using, that, at some point, the compulsion or the need to drink or drug is going to intersect, collide with a need to drive. And so it's just the best solution for a person who's demonstrated a tendency to drive more than once impaired is to effectively treat the addiction, the antisocial thinking, and other behaviors that go into that, and nothing does better than DWI courts for that population that we call high risk of doing this again and again, and high need. That's what it's about. And there's some challenges to us getting this done. One of the challenges that we know about is that there is sometimes the belief that DWI courts are only for alcohol impaired driving. Yes, that's how we got our start. And yes, even today, the majority of participants in DWI courts are those whose primary substance is alcohol. But even for those, that's rarely their only substance. And what we know about, my man talked here about the fact that in Alabama, I went to school in Alabama a little bit though. I went to school, a little bit of school at Oakwood College in Huntsville, Alabama, for just a little bit before I decided not to be a minister. But that's another story. We'll do that the next session. I'll tell you about that. That's a different one. When Bill talked about that, for the first time now, that marijuana, impairment has overtaken alcohol. That's going to be happening all across the country, and meth is not far behind in some places. So there is the perception sometimes that that's all DWI courts are for alcohol, but that's not always true. And the same kinds of underlying addiction and antisocial thinking and sometimes pathology that is a part of alcohol impaired driving also applies to the others. And so individuals who are driving impaired under any substance repeatedly, they're a better fit in a DWI court than they are in a traditional court. And they are a better fit in a DWI court than they are in a regular drug court, if it's available. And one of the challenges, Mike, is that the confusion is not just among the broader justice population. It's also a confusion sometimes among drug courts themselves, DWI courts themselves, recognizing that you are not a driving while intoxicated court, which sounds like alcohol. You're driving while impaired court. So that's a big challenge, being sure we understand that DWI courts are for more than just alcohol. And then, because of how long the process sometimes takes, not identifying candidates for DWI courts soon enough and placing them early. The earlier we can do that, evidence says, the better chance we have of preventing future misconduct. So meeting the challenges, I believe we need more DWI courts in communities. We have many more adult drug courts than we do DWI courts. We've got to try to change that. Our goal is for a drug court, within reach of everyone in need. We need that includes DWI courts. We also need to do what we can to educate the justice system at large regarding our intended population. We want the right people in DWI courts, but we also want to be sure we're not taking people who do not need DWI court. If there's not an underlying addiction issue and the related issues, then they need to be served somewhere else. That's super important. And we need, throughout jurisdictions, earlier and wider use of tools that can assess and identify individuals who are likely to drive repeatedly. And because, CARS as well as the IDA doesn't do a full enough job identifying folks who may be living with substance use disorders for substances other than alcohol, those screeners and assessments need to be supplemented with those that also identify problematic drug use, substance use other than alcohol. So I'm looking forward to having some more discussion with you and answering any questions you have. But I also want to thank you on behalf of the National Association of Drug Court Professionals for the work that you are doing. The fact that you are here today certainly suggests your interest. Thank you to responsibility.org as well as to the Governor's Highway Safety Association and AAA for this invitation. I've gotten so rusty, I forgot to bring business cards. I have got to get back on my game. But you have my email address there, as well as the email address of our real expert, the director of NCDC right there. Please reach out to us if there's anything we can do for you. Look forward to talking.
Terrence, after that, I would make the strong argument that I believe you are a minister.
Yes.
You are a minister of DWI in drug court. So thank you for that. Your passion is really something that I find inspiring. And that's one thing that I really like about working with professionals like all of you and like everybody in our audience is the passion that runs so deep for making a positive difference. And that's exactly what we do. I'm a big proponent of DWI courts. Just a quick story. As a very young district commander in a very rural part of Minnesota, when they first rolled out the DWI court in one of our counties, they invited me to sit on the panel that was establishing this. And the first session were I think there were 2 or 3 enrollees who were attempting to, prove their worthiness for the DWI court process came in. And the judge and the prosecutor and everybody explained what the roles were and then what the expectations were. And then finally, what everybody was willing to do for these individuals to help them succeed. And after all was said and done, I'm walking out and I grabbed one of the individuals and I asked him, hey, well, what do you think? And, here, I'm a state trooper, I'm in my uniform, and, this is a guy that had made a couple bad decisions. And he looked at me and he said, very simply, what's the catch? And I said, what do you mean, what's the catch? He says, these people are going to help me be better and not do this again? That just did not fit. And he went on to be the first graduate of that DWI court in that county. And so they do work. And the judicial ignition interlock program also. We have one of those in Minnesota, and yes, highly successful. The biggest problem we have is trying to find more ways to fund those, and that is a resource thing, and some of the restrictions that come with the way you can spend some of your federal money. So great presentation. Thank you so much, Darren. Your Honor, are you up next?
I think so. I just want to let everyone know it's really an honor for me to be here with you. I'm not the only judge. Our judicial fellow, Judge Axel, is back there, and 2 other JOLs, Judge Rosinski, Judge Hassel, are here with us. And one of the biggest things from the JOL role is that concept of having the judiciary work within our constraints. We do have constraints, but working with as part of a system that is effective. So really is an honor for me to be here with you. Terrence, I do have to say, I've presented with you a few times, and I don't think you'll ever forget how to present. Not gonna happen. It's just not gonna happen. But it is an honor to be here with the panel and to talk about something. And what I'm gonna talk about today a little bit, I call it an evolution. So if you look at court involvement in DUI cases, it was just the sentence, the jail time, and courts really didn't get beyond that. The case is over, passed it off. Courts really didn't get involved in being part of the solution. Okay, then DWI courts came along on the DUI side, changed that dynamic, and started talking about treatment and working with people who need treatment and getting them in, using the leverage of the court to get them to treatment. So that was a huge and giant step forward. And then the next step, though, the question that I'm going to ask you to think about as we go through this, What about those ones who are high risk who don't need treatment? What about those people? What are they getting? What are courts doing with the supervision on those individuals to really make them accountable and do just like Terrence said, prevent that next or subsequent DUI? So I'm going to talk to you a little bit about court. This is different. My favorite researcher bought me one of those joke ribbons that goes below the badge, and the one she chose for me was I color outside the lines. So that's me. I am the out-of-the-box guy, so to speak. So what I did is, and I also have a mind of a systems engineer. So what I try to do is put things together and make them work as an integrated system. So we started, and I was given some rules, because when I went to start my DWI court, I was told, at least the grant funder that we were going to, no, we're not going to pay for treatment, but I will pay for monitoring. So I gave me a little something, right? So I started with a court that was focused just on monitoring and using monitoring alone. And then, of course, what did I find out? Though those people I'm monitoring, some of them need treatment, right? So I had to develop this system called a multi-track system. On the DUI side, I don't know of any place that's been done outside of California. We are doing it in San Joaquin County, but then 2 other counties have kind of adopted the model. Monterey County and Fresno County have adopted in. I know that Missouri, who's doing the multi-track model, not on the DUI side, but on the other side, they have a lot of courts doing it. And they have at least one court that's looking to bring it onto the DUI side. So this is, it's new. It's a bigger box, so to speak. It's going outside that box. So the way it works for us is at the arraignment. Most of the arraignment, we designed our system so the arraignments come in front of me, and I'm about 95% plea at arraignment. So almost everybody that appears enters a plea on that day at the initial arraignment. So then they're going to enter into, this is a little bit different in that it's not optional. I'm blessed in California to be operating under a system where misdemeanors that come to me on a DUI is going to be a 3-year grant of probation, and it's a 5-year grant of probation. It's a second. So I have the ability to really design a system. And it's really the judge's sentencing option to design the conditions of probation to match what somebody needs to supervise. So I have a system in my state that lets me do really well. So they'll enter the plea, and then the very first thing I'm going to do is a screen. Okay, and I love the screening triage tool because I can do it immediately right there in the courtroom in real time. So if somebody enters a plea and they have a prior conviction, I really don't pay attention to first offenders, because I don't know that there's a reliable enough to tell me who's coming back, who's not coming back. A lot of people could come to the conclusion you're being really overly big brother. But the minute somebody gets convicted once and then comes back again, they're telling me they're high risk. They're telling me that because they already reoffended, right? So we'll do this screening tool, and then the screening tool will break it out. If I were to send them out for an assessment, I'd have to send them to somebody else, tomorrow to appointment, and then come back a week later. I'm going to lose 50% of them, right? But if I do the screen right there in the courtroom, it's done right there. It takes literally 5 to 10 minutes to get a screen to tell me which quadrant they're in. Then I call them back and I tell them which day they're coming back to court, and we get them started. Monitoring for everybody. So everybody who has a repeat offense in the jurisdiction, we put this in, gets monitoring for a period of 1 year. They have to abstain from alcohol and drugs for that year, and then they have to report back to me, so that the parent, so that I can make sure that they're following those orders. The RANT puts them in quadrants for me, so it lets me know where they are. Now, what Terrence brought out, the high risk, high needs individual, that person needs to be evidence-based in the DUI court. That is what the DUI court is all about. All the study shows is the most evidence-based tool for that individual. If they're not in the high-risk, high-risk quadrant, our practice, we just use monitoring for public safety to make sure they're doing well. This is the 1 year monitoring group. So they check in. The monitoring could be, we use ignition interlock device. We also use mobile monitoring, the handheld devices. We also use transdermal monitoring. And we don't demand anything for any individual because there's no one size fits all. Every client's life is different. So what works for one isn't going to work for the other. So we try to make sure that we match it up with the individual's needs. So This is what I think is really, really important. We started doing the rant in 2015. So between 2015 and the end of 2019, I don't count 2020, the numbers are going to be just too weird. But between 2015 and 2019, we did 1,673 screens. That's a pretty big number, right? And this is how they scored out. So if you look at it, 29% of them were in that high risk, high needs category. They needed to be in that DWI court. And I was, through perseverance, followed through and made sure that we got the DWI court in, and it does absolutely work. But the question is, what about this other number? In most jurisdictions, that other 71% gets absolutely nothing to make sure that they're doing what they're supposed to and things. I call it the great gap. Okay, this is what that year-long monitoring program takes care of for me. That year of monitoring addresses this other 71%, is how it comes out. So it's the concept is to target that 71%, and it doesn't compete at all with DWI. It complements it. This is part of one system. This is one system, okay, that meets the needs of all the high-risk DUI offenders. So I told you I'm a systems engineer. That's kind of sort of the way it was designed to be. So as you look at it, this would be the pie chart of what our overall track numbers are. So actually, that was 1 year old, the last one. It's about 72-28, the last part. And I'll tell you a little bit about how we get there kind of at the end. All right, so I am going to share with you, I think, some research. This is so new. We weren't able to put it into the slide. We just popped it into the slide. I just got it from my researchers. By the way, we don't have our final report yet. This is just a chart they prepared for me so we could bring it here so I could present it to you today. That's how hot off the press this is. So I have two tracks, right? I have monitoring track and a treatment track. So this last study we did, we compared the tracks. We compared the recidivism rate between the tracks. Everybody is high risk in this group. So it's an apples to apples comparison. They're all high risk. And this is the recidivism rate for them. And you look at, there's a pretty substantial difference in their recidivism rate, right? But you'd expect that, wouldn't you? Okay, the key here is by coming in on that second offense and using the year-long monitoring, just like Terrence said, we're getting earlier in the process. We're actually catching them before addiction, if you follow what I said. And when you catch somebody before addiction, it's a heck of a lot easier to work with them. I'm here to tell you. So it's cost less, it's more efficient, and you actually get better results. And the number is pretty good. So in our monitoring track, and this tells you the kind of idea of the difference how they break out. There were 922 over this group versus 121 in my treatment track, and that's kind of a percentage how they break out. So the DWI court, this group, absolutely. This group here, if left alone, your recidivism will be up there, but you're dropping it down by providing that alternate or that kind of second track that allows it to do it at a monitoring court. Oh, like Shannon keeps putting the red circles and stuff in her bed.
Like that.
Yeah. So I talked to you a little bit about costs. These are my costs. So look at the cost difference between my treatment track and my monitoring track. It's off the chart in terms of cost. So this population is a lot bigger population, costs me a lot less, okay? And previously we're having nothing. So what the DWI CART principles and everything kind of led me to was this concept of working with this other population. So not just limiting it to the one group, but expanding it out to everyone. This one is huge. There has been some studies on ignition interlock device in California, and or in any type of monitoring, if you're a judge and you order the monitoring, but you don't verify installation, you might as well not order it because people aren't going to do it. Okay, so if you order monitoring, you have to verify that it gets installed. If you verify installation with ignition interlock device, there's a study out there, 3 months recidivism reduction, boom. With transdermal, 4 months, that study was a little bit longer, reduction recidivism, done. The problem is, both of those studies show the minute you take it off, reversion to norm. Okay, so it's good for while it's on, but reversion to norm when it comes off. What we found, this study came out last year for us. It's a longitudinal study. So we were studied in 2012, and they found like a 32% reduction in recidivism with our group. This took that same group last year, and NPC followed them out for 6 years. And what they found, the researchers are telling us, this is strange, we don't see this, but the reduction in recidivism actually grew every year for 6 years. Wow. Okay, that is long-term behavior change. That is not, just, that's long-term behavior change. And it's actually huge. And one thing I think this study is going to be representative of for the monitoring folks that are here. 1 year of monitoring works, and you don't get a reversion to norm. Okay, at 3 to 4 months, you get a reversion to norm. I don't know, 6 months, maybe another court, maybe you can try 6 months and see whether they get the reversion or norm. But 1 year monitoring is huge in terms of the reduction in recidivism. So some takeaways, we need to make sure sentences have to be individualized by clients. Mandatory minimums do not work. Okay, I do have some mandatory minimums that I have to impose because it is the law. But I do also have the option to use alternative programs, so those work. DUI offenders are often in denial, and this is one of the things that really distinguish that DWI court track person and the monitoring person. The DWI court track person, that person has chemically rewired their brain. They can't stop. Okay, they're pre-programmed. If you want abstinence from that individual right now, you have set up failure because it's not going to happen. You have to meet them there and walk them forward. Very patient. You're going to do a lot of different type of treatment with them. The monitoring person could stop anytime they want to. They just don't want to. They're not a criminal, and you shouldn't be able to make them. Anybody recognize that person? Yeah, and that's that person. It's that denial. I once had when I was in my prior career as a prosecutor, I had a public defender. We're waiting for a jury verdict on a DUI case. Really experienced public defender. He's like, I hate DUI cases. I hate them. And the judge and I just kind of look at him and say, why? He said, because if you give me a client charged with murder or rape, I can take the crime report back to him. We can look at the crime report. We can talk about what the witnesses are going to say. We can talk about what the evidence is, and we can come up with a plan. So you give me a DUI offender, I walk back with the crime report. They look at me and they say, I'm not a criminal. I'm not a criminal. I can't get past, I'm not a criminal, right? This is that group. So with this group, it's not about addiction dependence. It's about dealing with that thought process, like Terrence said, that's telling them it's okay to do things that they know they shouldn't be doing. It's a very different very, very different. A lot of great tools in terms of working with this individual that we have. Now, I have to share something with you. I do the multi-track DUI court, and I know 2 judges very well in Missouri who are doing the multi-track court on the traditional justice system side. Every single one of us agrees that we think we make the most difference on that high-risk, low-need person. That's the person that needs the judge the most, because all they need is somebody to hold the line and tell them, yes, you do have to do what you're supposed to do. They need the parent, okay? So it's just a coincidence. All 3 of us judges talk together say, yeah, we think we make the difference for them. So you making your decisions of how you break people out, it can't be a one-size-fits-all. It has to be based on an evidence-based risk. DUI offenders are different, so it needs to be a DUI validated tool, because if you use a traditional justice system tool, it will always underscore it. And then what the monitoring courts do, or the monitoring track and the DWI court do, what these courts do is they fill that gap. They fill that gap that is between the traditional DWI court person and that person who's getting nothing. So they provide that just by bringing accountability in. I'm here to tell you, accountability really is the magic elixir. All right, it works for everybody, judges too. As human beings, we all tend to behave really well when people watch what we do, right? The minute people are looking the other way, maybe not so well. But it is a very highly effective way to do that. Oh, I think we're to Joanne. So with that, I am going to leave you. There is one other slide on the reduction in the recidivism stuff. We've got that. I think we're good. No, I think we did. We got it. I switched them out. We should be good. We did the reduction. We did the cost. But I thank you for your time. I'm just really excited because, I mean, there is an evidence-based system that we can put in place that can really do that prevention thing that Terrence is talking about and preventing that next DUI from coming down. Thank you.
Thank you very much, Your Honor. Thank you, Your Honor. The one line that really stands out to me there, which is, I think, where we're all trying to get to, is color outside the lines. Find that innovation, find that creativity, and that individualized approach. And then finally, Joanne, want to come up and talk to us a little bit about some training and things like that?
I'll do it. Thanks, Mike.
All right.
Good morning, everybody.
Morning.
My first thanks go out. Well, let me start. I'm the director of the National Traffic Law Center at the National District Attorneys Association. Please raise your hand and be honest if you've never heard of the National Traffic Law Center. Okay. That makes me sad. And when you leave, you're going to tell 500 of your friends about who we are and what we do. Because we were created to help all of you. We were created by a vision from the National Highway Traffic Safety Administration and a couple of people at the National District Attorneys Association who said way too many people are dying. Way too many people will never be the same as a result of what happens on our roadways with impaired drivers. There are way too many Swift families. And Mr. Swift, thank you so much for your motivation and your dedication and for the lives you've already saved and what we're going to do together. I really appreciate that. And I look forward to getting to know you a little better. So that happened. And we all said, hey, why? We're really smart people. We should be able to figure this out. We should be able to stop some of this trauma, some of this forever trauma. So we did. We got together and said, how can we as a prosecutors organization help in that fight? And I'm happy to say we're standing here now, over 25 years later, still fighting the fight with all of you in this room, but we're doing it collectively. And that's the biggest thing I can say about who we are and what we do, is we're doing it collectively. And we're very, very happy to announce, and I think Darren had it up on your screen when we all walked in yesterday, that the National District Attorneys Association, my parent organization, is now an ally of NACID. So you will see me, you will see some of the members of my team, and I call them a team because we are. If you can't get a hold of me for one reason, any member of my team can help you. So please know that. And all of our contact information. That is so funny you said that, Terrence. I also forgot my business cards. I thought about that this morning. That was hilarious. But we are here, and all of our contact information and some of the resources that I'll talk about are also going to be linked on the NACID website. And I think, Sam, you are the guy. Be me and you later, me and you. But I want to talk to you about what we do in terms of training to help fight substance impaired driving. And I'll leave out I'll leave out alcohol. I'm just going to call it substance because that's what it is. Every time we have an impaired driver on the road, there's some substance that makes them not who they are in a natural state of consciousness, right? First and foremost, I want to talk about the work that we do with our traffic safety resource prosecutors, Bill Lindsey and Jen Knudsen, and the other states that we have around the nation, -3. I'm happy to say, and 2 of them are going to refill. We have a current vacancy in the state of Alaska. Now, if any of you can work with us to get Alaska on board with a TSRP again, I will be your new best friend. And it's good to be Joanne's friend sometimes. It is. But we need to get Alaska on board. We're having transition in Virginia right now. We're having transition in Pennsylvania, and we're having transition in Puerto Rico. But all of them are looking, they're actively engaged in filling their vacancies. That leaves one state in the nation, just one. Let's bring them on board. Because the work that these guys do in their states as their state top of the line expert in traffic safety, all things traffic safety, is phenomenal. And this program was also developed with funding through the National Highway Traffic Safety Administration about 15, 16 years ago, if I'm right, somewhere in that neighborhood. Okay? And they are experts. We will provide the most current list to NACID, so it will be on NACID's website. It's also on my website. So you can find that at any point. If you're having any trouble, please never hesitate to give me a shout. Okay? But the work that they do to set up their trainings, to put on conferences, to provide you with resources, we work with them every day to say, what is your need? Because what Jen is seeing in Colorado may not be yet what Bill is seeing in Alabama, and it may not be seeing what I see in the Commonwealth of Virginia where I live. Okay? I don't talk like I'm from Virginia by any stretch of the imagination. And even though I worked for and lived for 19 years in Syracuse, New York, I am also not from Syracuse, New York. If I park my car and tell you, go Red Sox, that's the true Joanne. Okay, so anyway, so your TSRPs are critical to what you do. And we want to be just as critical for you. We want to be that group that you turn to in terms of the resources you need to do your work, to help form committees, to help put coalitions together, to get resources for training. Because I just want to overview, because Darren asked me to talk about what are the biggest challenges facing training across the board. And it has to start out with the concept that a substance impaired driving case is the most complex case in the criminal justice system. Now, this is a horrible phrase to use, but we all have in our DA's office some murder snobs, right? They think they make it to the homicide unit and that's the be all end all worst case ever, okay? Well, anytime we have a victim, it is the worst case ever. But our cases tend to be some of the more complex that ever go into a courtroom. And I just want to review that. I think I'm kind of preaching to the choir, but maybe some of you have never really sat down and thought about the complexity of these cases. All right? So our burden as prosecutors, remember, our burden is extremely high in a criminal case, beyond a reasonable doubt. And as all of our judges know, judges often get overturned for the definition they give to the jury. Our cases get overturned because of the definition they give. So if our judges are having a tough time doing it, imagine those poor jurors trying to figure out what is beyond a reasonable doubt and did we prove it, right? So that's a huge issue right out of the chute. What does that even mean? But then we have to do that for each and every element of the offense charged, right? We have to prove operation. Was this person actually operating a motor vehicle? And were they operating it in an intoxicated condition on your roadway? And all of these are defined differently in our 50 states. All three of those are defined differently in our different states. And then if there was a crash, what caused the crash? Okay? And if there was a death or a serious physical injury, what actually was the cause of the death or the serious physical injury? Was it a result of the collision? Was it the result of some other factor within the victim? What caused it, right? So let's think about quickly about those steps, because we have to be able to train all the players I'm about to talk about, right? Okay, first we have to train our road officer. So we think we do that in the academy. That's wrong. Okay, as I was talking to Chief Myers this morning, they're so inundated with information they could barely spell their children's names when they get out of the academy, right? Let alone how to understand the standardized field sobriety tests, and instruct accordingly, watch the demonstration by the suspect, and then report back to court, okay? But we have to have those officers, so they have to be trained on how to stop a vehicle, right? To look at all the cues of the driving behavior. We then have to make sure that they're administering the SFSTs correctly, they're recording the cues, right? And then if they see something that may be a little off kilter, they have to be trained to know that something else is off kilter. Like maybe there's something else besides alcohol going on. So they have to know, well, what do I do then? They have to be trained to know what to do then, to call a DRE like Christine Frank, right? They need to know that. And then I need to have a trained DRE come out and perform an evaluation, and maybe we have an A-RIDE officer in between, right? I'm already up to 3 officers and we haven't even made, an arrest yet, okay? That I need to bring into my courtroom. So now I have a DRE, and then I have the DRE that, makes the category, draws the decision of impairment. Then I have to have somebody get the sample. So is that a phlebotomist? Is it a law enforcement phlebotomist? Is it a doctor? Is it a nurse? Okay, so that's another witness I have to bring in. Or it might be a certified breath test operator that also has to be trained on the instruments. And we all know there are a lot of instruments out there. And I have to just say, and thank our vendors for providing good resource tools for us for quick education about all the components of their instruments. But I haven't even gotten the prosecutor really involved yet. So I have to have all these trained people making that decision of impairment, getting us that sample. And then we have to get our friends, the toxicologists, involved. So then I have Amy Miles involved, right? Or I have Christine Frank or Jennifer Harmon getting involved in analyzing the substance. And then when I know what the substance is, I might need a medical doctor to testify about what is it in terms of dosage of this substance. Like we found the pill bottle, but she said there was this much in the system. Can you equate that to me, doctor, and tell me what some of the signs and symptoms you would expect to be visible? And then I also have to know the limits of the toxicology report, as these guys so eloquently went over, right? There are limits about what these numbers mean, okay? So I have to understand that as well. And then we go from that to what if there's a crash, okay? What if there's a collision? And that A word, Jen Knutson, is not wrong. I'm militant. I am more than soapbox. I almost yelled from the back of the room at my friend Jamie Derbyshire yesterday, who used the A word, okay? It's a bad word. It's a bad word. It is a painful word, if I'm not mistaken, Mr. Swift. I've never been in your shoes. But it's a crash, it's a collision, it's a devastation, it's an explosion. It is anything but an accident, okay? So now I have one of those. I have a crash. Thank you. I have a crash. So now I have a crash reconstructionist. And now I have perhaps a road engineer who's got to talk to me about the road design. I have to understand all the technology in a vehicle, right? Because now we have to figure out what happened. How did that car end up over there? And how did that person get ejected over there? Who was the driver? I have to understand occupant kinematics, to understand the movement of the body in the vehicle, because everybody's out of the car by the time I get there, or the time the police officers get there, right? And then I have to have the medical examiner, because I have to understand how this person died. And I have to prove that the cause of death was related to the actual crash. So I didn't do my math, but I think that's about 10 potential witnesses without having someone like Jake, who saw the guy going 110 around the curve and a girl screaming out the window, right? So that's 11. And then whoever else I have, or body cameras, I have to understand the technology of body cameras, dash cams, Any cameras on the bodegas, you know, that caught the driving behavior? All of those things, we have to try to train our prosecutors to understand each and every one of these steps of our prosecution. Because if I can't communicate with Deborah Coffey about the instruments that were supposed to be in place, right? Or I can't talk to somebody from understand how the Draeger instrument worked when we took the sample, or I have no idea what a gas chromatograph mass spectrometer really is, other than a big giant thing that tells me there was cocaine. I have to be able to talk Amy's language, and she has to be able to talk mine. Right? That's the biggest challenge, because all in all, our job is to do that proof beyond a reasonable doubt. So what we need to meet the challenge of this really, really high level training need is to do it together. The best thing that I've seen in my prosecutorial career and in my career with the National District Attorneys Association is that transformation to joint trainings, where I sit down next to a law enforcement officer like Darren or Brian Orsino. We're working these cases together, and we're like, why don't we do that? We should be doing that. How come you don't call me out to the scene, right? How come we don't know this? Hey, the next time you do a training on getting evidence out of an event data recorder, can I come? Can I watch that training? Because you and me, we got to describe that to the jury. And I need those jurors to go like this, like, I get it. Because if those jurors are looking at me like, I don't know what the hell you're talking about, I'm done, I'm not listening anymore. The first time I see that head turn, I am in deep trouble, right? So our challenge is to be able to get the time, to get resources, and to get the buy-in from leadership to understand the criticality of these trainings. And I'll just do one more soapbox moment before I get the little sign back there that I'm all done, is, you know, as Jen said yesterday, and Bill said today, often these go to our newest prosecutors. And please, another soapbox moment. It's not quite as dramatic as the A word, but please don't ever call us baby prosecutors. Okay, you can call me new. Okay, you may call me inexperienced, but I'm not a baby, and I am a licensed attorney to practice law, and I took an oath to be a prosecutor. Okay, that's the end. But may you never forget it. Never, think of this face, right? She'll come after me because she's as mean as she looks, all right? So anyway, that's our challenge. We have to find it. And the final piece to this, and I mean no disrespect in terms of, you know, cutting this off, but where is Mark Stodola? I've learned more about probation and parole than in the 16 plus years I was in the DA's office. And the critical importance of working with our parole officers, because we as prosecutors never got training about what happens next. And that is such a critical piece that we can be involved in to understand what these people need. You know, I can read a pre-sentence report like anybody else, but to really understand what else is the problem and what are the tools and resources that are out there to individualize this sentence. Because I'm the biggest proponent to say accountability is the biggest piece. We have to hold these people accountable or their behavior will never change. I'm a firm believer in that. I hope stats back me up on it. But the tools that are out there now, whether they be ignition interlock devices, whether they be SCRAM devices, DWI courts. So there's technologies, more technology you have to understand. There's more methods and training things that we can do to work together to prevent recidivism. So those training pieces are also critically important. And we learn about those needs from you. We learn about what resources we need to develop, like our cannabis detection monograph that we just developed because people weren't getting enough cannabis understanding and training. So we develop all of those. We have submitted to Darren, and I hope sent to Sam already, links to all of the resources that we have developed with the Foundation for Advancing Alcohol Responsibility, with the National Highway Traffic Safety Administration, with Federal Motor Carrier Safety Administration. Those tools are available Please utilize them. If you think of other trainings you want us to develop, that's how we do it. We do it by you telling us what you need. And I'm really excited to engage in some discussion because I got the big red 0.
Thank you very much, Joanne. And in case anybody wonders how passionate she feels about how we refer to our newer prosecutors, I would encourage further conversation there. So thank you. And you know, some really great points there. You know, the most complicated thing, as Joanne said, that most street cops deal with is an impaired driving arrest. When I look at Minnesota, my home state, our implied consent and impaired driving section in the traffic code had to be recodified about 10 years ago and has its own separate chapter now. And it's about 60 pages long. When you look in the criminal code in Minnesota at the manslaughter and murder statutes, it's about 8 pages. And so you just get a better idea of how complex these situations are. And it starts at the very beginning from initiating that traffic stop all the way through the system to that probation or that monitoring that takes place after adjudication. So we've got a lot of room to play and to work and to improve in all aspects of that. And just another exclamation point when Joanne talks about technology. One of the other hats that I wear is in the connected and automated vehicle world. And for any of you that think that cars are going to save us from ourselves sometime in the next 10 or 20 years, I got bad news for you. It ain't going to happen. But the knowledge that the prosecutors and the police and everybody else is going to need going forward for how the driver assist systems and some of these other technological advances are going to affect driving and what happens in the vehicle, that's only going to expand. Really, this has been a great discussion so far, and I want to give all of our attendees here, both virtually and in person, plenty of opportunity to engage. So please bring on your questions.
Mike, if you don't mind, we would like to throw an audible at you real quick, because after hearing from Terrence and Judge Vlavianos, we wanted to show a quick video that brings home and humanizes and puts one single face on the drug court program and the impact of that. So Kate, if you don't mind, we're going to cue up that video real quick. It's a short 5-minute video, but we wanted to make sure that everybody got to see this story. And I'll shut up and say one more thing when it's over.
Hello, sir. How you doing today? Good to see you. How's everything going?
Everything's good.
So this is the new spot. All right, give me a good strong blow. Good. This is probably going to be our last visit together. So I want you to close your eyes. Close your eyes. And I want you to think about everything that's on your criminal history. I want you to see each one of those charges. Okay? Now I want you to think about if we never introduced alcohol into your life, no drugs, no alcohol ever introduced into your life, would you have a criminal history? Okay, look at me. Alcohol has not done anything to put money in your pocket, give you more time, or give you freedom. I want you to remember that.
Being in the US, I didn't know anybody. I have a daughter. I named my daughter after my mom. I was supported by my parents. Unfortunately, I lost both of them. And that's where I took the wrong road, which was drinking to make me comfortable and calm.
He was a classic example of somebody who pled guilty and just took jail time, did not get any kind of support.
Repeat impaired drivers are a very dangerous subset of population who consistently use drugs or alcohol and get behind the wheel of a car over and over and over. Interventions prior to a DUI court really haven't worked for them.
I had the first DWI. I came out, I was sober for almost 4 or 5 years. And I got back to the same thing. missing something. And what am I missing? The tools to help me in the situations where I need it the most.
Issa had that conviction on his record and was offered the sober court program on the second DWI.
The special thing about sober courts is that we believe in change. We believe that if we give clients the proper tools, they will be able to put them in place and not go back again and drink and drive.
We have named them sober courts, which stands for Saving Ourselves by Education and Recovery, but they are our DWI specialty courts. And the mission is to use an intensive rehabilitation program with a team concept to support the clients in their recovery. We do that through education, supervision, and treatment, and wraparound services, and that's the beauty of the program.
Not only do we have our awesome case managers that provide a lot of hands-on during the day, Sheriff Gonzalez has given us 3 deputies to do after-hour checks.
A lot of times you'll see, I'll get a tear in my eyes because it's almost like watching your children. You see the evolution, you see them evolve into the new person they're gonna be sober.
The beginning was tough. Sober Court want to help people in addiction get out of it.
As the weeks went on, we started to see him really blossom. And I think that came out of some confidence that he was building as he was going to treatment and learning that he could be strong enough to not resort to alcohol whenever he faced adversity, because he has faced quite a bit of adversity in his life.
It has been a long journey. I faced a lot of big challenges in my life. Alcohol has been a burden for me, almost destroyed me. But luckily I had people like you guys to make me believe in myself, and I'm so grateful.
It's so much better for these folks because it equips them with lifelong skills that they are not going to get if they sit in jail for 30, 60, 90 days. In the end, he's been one of our greatest clients because he's done so well. He is committed to a lifetime of sobriety now.
Through that program, I learned if somebody can do it, why not me?
Well, thank y'all for letting us do that. We obviously would have been remiss not to show that after this panel discussion. But this was just the trailer, and it's produced by all the fellas in the back with the headsets on. And that's the full-length version is about 20 minutes long, and you hear a lot more from Isif himself. You hear his full graduation speech. It's very powerful. And it's currently in the film festival circuit, so we can't show the full thing, and I know you're sad about not having to watch that for 20 minutes, but it's a very powerful story, and we hope that when it is able to be shared, because we can't do it now to jeopardize the award submissions and that sort of thing, but that you guys will help us amplify that, because I think it does a great job of putting a face on that and explaining the issue just and humanizing it. So anyway, thank you for letting us do that.
All right.
Very well done.
Yeah. Very good. That was, I think, a good audible call. So thank you for sharing that and giving us the preview on it. We really appreciate that. And now, without further ado, questions. We have one right here from the young lady on the side.
Thank you. My question's for Judge V. So Judge V, one of your slides said that you recommended individualized sentencing and not mandatory minimums, but yet your longitudinal study was successful when they were in the program for 1 year. So can you comment on that?
Oh, absolutely. The sentence time that I was referring to is the time in jail. There are minimum times in jail, and I have the ability to use alternative programs. The monitoring time is not optional. So the monitoring time is a year long, and one of the things I'm most excited about is the data that shows that 1 year of monitoring really gets that change. So yeah, it's the jail time was what I was talking about on the mandatory sentence. The monitoring isn't mandatory. I'm just adding it as a condition of probation because the judge thinks it needs to be a condition of probation.
Thank you.
I'm going to steal a book out of the Darren Grondell playbook, and I'm going to ask one. And so, Terrence, from the DWI court standpoint, what else can the DWI courts be doing that maybe they're not doing right now to make them even more effective?
Well, I appreciate you asking that question. And while many DWI courts are doing this, what's most important is fidelity to the model. So if brand new drug DWI courts are starting and they haven't got training, they're not versed on evidence-based practices, or maybe it's a drug court, a regular adult drug court, now trying to begin establishing a DWI track without training. That's where you don't see the outcomes that DWI courts promise. So the most important thing is to avail ourselves of all the resources that are out there to be sure that DWI courts are informed, those that exist and those that are new, because we know this works, but not always. And when it doesn't work program-wide, it is often because of not implementing the elements of drug courts and DWI courts that we know get the outcomes.
Very good. I think that's a great way to put it. Question back there, sir.
Yeah, for either Mr. Walton or Judge Vlavianos, for those programs that are faithful to the model, how do the recidivism rates compare for that high-risk, high-need population compared to from the DUI court program compared to those who are going through traditional court? And if there's anything else that you all attribute to the success in those programs?
Well, I'll just give one stat that is Millar's meta-analysis of DWI courts across the country, where it found that when compared to traditional court, that DWI courts get about a 60% reduction in recidivism compared to others. So there are other smaller studies, other studies state by state that show the same thing, but this meta-analysis shows that. What do you want to add?
Yeah, I mean, the data is in. I mean, it varies jurisdiction to jurisdiction. I think Athens but the highest rate with their graduates one, but it varies jurisdiction, but it's all a significant reduction in recidivism. Every court, every area is different. We all have different strengths. We all have different weaknesses. We have the principles that guide us, but we have to make it work within our system, which is never exactly the same. So every place it is a little bit different. What makes it work is the judge's involvement. 70% of the graduates from drug court say the most important thing to their graduation was their relationship with the judge. It's this thing that, and it took me forever to understand this. A judge saying positive things about you to the clients that are coming in front of us changes the world. I mean, they just don't get it. And I used to always undervalue that. But then I thought to myself, you know what? The functional equivalent for me would be the governor sitting in my courtroom, telling everybody in the courtroom, man, I'm really proud of you. You did, how good would I feel, right? So it's the use of that accountability to the judge and that parental role that only a judge can bring, that the accountability and the role of the judge bring the magic to the whole group of high-risk offenders. The treatment folks, the judge needs some help because the judge can't do treatment, right? So the treatment folks, you got to bring the treatment community in, interlink them, and the treatment program will carry them through. Even though the treatment program does most of the work, the clients give most of the credit to the judge, which I think, quite frankly, isn't fair because the treatment program really does do most of the work. But it's that value of that relationship with somebody important caring about what they do.
Okay, very good. Well, I know that we are running up close to lunch. We got time for one more quick one.
Yeah, maybe you can just repeat the question. Here you go. My question's for Joanne. I'm curious, I've known you for a while. I know what you do. I know what TSRPs are, but it never occurred to me all that they have to know to train their peers. What do you look for in a new TSRP, and what's the onboarding process to get he or she to the level of expertise where they can now train others?
Thanks, Jake. That's a really good question. There is no uniformity in selection process of traffic safety resource prosecutors. They're selected from within their own state. Sometimes it's the Highway Safety Office itself that will select the TSRP. and define the criteria for how much legal experience they've had, how many years as prosecutor, if they've been a trainer. There's never been a set development of requirements, and I think maybe that's something we could look at, but each state has such very specific needs. So we look to them to get the person with the best experience. We're there to help guide them. As an onboarding process, the Traffic Law Center, we reach out to them and provide them with some of the fundamental tools that we have, all the training curriculums we've developed through NHTSA, all the resources from our website. And we also put them in touch with all the other traffic safety resource prosecutors. Through the National Association of Prosecuting Coordinators, which has also had some funding from NHTSA, we're developing a mentoring program. So when a new TSRP comes on, they're given an automatic contact to someone to be a mentor in their region so that they can help see what does Bill Lindsey do if, say, we have a new TSRP in Puerto Rico. You know, what's happening? What do I need to look for? What do I need to start implementing in my state?
Very good. Okay, everybody, just a couple of things to wrap up really quick. The story that I shared with you at the very beginning, the complaint and the overdose and everything that went with that. Just to wrap that up and kind of bring it full circle, the two kids were both under the age of 10. Both of them were suffering from not heat stroke, but just they had been in the car for quite a while and heat exhaustion was setting in. They're both fine, and they are both now in foster care. The driver who recovered has been charged with third-degree murder, as was the supplier. They were able to do a really good, really quick investigation and put the grabs on the actual drug supplier in that case, and he is also facing a third-degree murder charge. So a tragic exclamation point, but with the outcome that hopefully will help prevent some of these things in the future. Finally, Brian, thank you. Every rocket launch starts with a spark. Thank you for being the spark. And thank you, panel members.